Sir,
SK Goswami.
SK Goswami, comma with the consent of the other side has prayed for adjournment, list the matter on 25th November.
Must be. Apply Lordship.
May I plead for Lordship?
Mm.
Lordship, with the consent of the other party, Lordship, I'm going to mention item number 3 and 4, Lordship. Okay. Today we have filed the amended cost title, Lordship. Only this may be taken up after 3 weeks.
Your Lordship, I appear for respondent number 1 in item number 4.
Hmm. But this is a matter of 17, no?
Yes, Lordship, we have,
You have come across the Supreme Court's direction.
Lordship, today only we have filed the amended cost title. It is not on record. So
Okay.
let it be after 3 weeks.
All right. Learned Counsel Miss
P. Borwa, Lordship, for the appellant.
P. Borwa, on behalf of the appellant, has submitted that today the amended cost title has been filed, so an
In item number
adjournment, huh?
3. In item number 3, Lordship.
Amendment cost title has been filed in MAC appeal number 155 of 2017, and so an adjournment has been sought for, SOUGAST sought for. I'll stop. Learned
Sorry,
Counsel-
item number 4. In item number 4, we have filed the amended cost.
I have item number 4 or
In item-
159 in the 55 was. Learned Counsel Miss
A. Biani,
A. Biani is present for respondent number 1.
1. In item, yes, Your Lordship. And-
And respondent number 3 looks.
And
New India.
Learned Counsel Mr. AJ Soki is present for respondent number 3. List this matter after 1 week,
After 2 weeks, Lordship.
after 2 weeks,
Yes, Your Lordship.
positively for hearing, as this is a long pending matter.
Much obliged, Your Lordship.
একেবাৰে কৰিব পাৰে।
May I please, Your Lordship?
Mm.
With the consent of other side, I would mention item number 9.
Mm.
Lordship, the conduct counsel, Mr. SK Ghosh is out of station. Matter may be taken up after 1 week.
Adjournment has been sought on behalf of Learned Counsel Mr. SK Ghosh, with the consent of the other side.
Your Lordship, a date may be fixed
List this matter on
on 24th of November, 27th.
27th.
Okay,
November.
20. Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 6.
Mm.
Lordship, as my senior is suffering from some illness,
Mm.
kindly agenda matter for the next week.
Learned Counsel Mr.
BK Das. On
You-
behalf of BK Das,
You are,
for petitioner,
what is your name?
Pranab Medhi, P. Medhi.
P. Medhi has submitted that his senior, Mr. BK Das, Learned Counsel Mr. BK Das, is not well. What about the other side? You have taken consent.
For petitioner,
Okay, list this matter on date dear. A hearing also too. Hearing, no, on 27 November positively for hearing, as this is a long pending matter. Okay.
Masam.
May I please, Your Lordship,
Mm.
I beg to mention item number 2.
Hmm?
Item number 2,
Okay.
we have taken consent of the petitioner, Your Lordship.
No. This is an old pending matter.
Yes, Your
You
Lordship.
see, these are,
Your Lordship, it can be fixed on Tuesday. So we can try for disposing this of it. Since it is old pending.
Learned Counsel Miss
S. Musahari.
S. Mutahari, with the consent of the other side, has prayed for adjournment. List this matter on positively for hearing without fail, as this is a long pending matter.
Obliged.
Obliged.
May I please, your Lordship?
Yes, yeah.
Lordship, I would like to beg for item number 12, supply list, with the consent of the other side.
No.
I would like to beg to the court for after a week, to list the matter after a week.
You have taken consent from the other side.
Lordship, I am from the respondent.
See, these are all old pending matters.
Yes, Lordship, after a week.
Learned Counsel Miss
D. Hazarika.
B. Hazarika, on behalf of Learned Counsel Mr. J. I. Bobia, comma, with the consent of the other side, has prayed for adjournment. List this matter positively for hearing
Lordship,
on
after, can it be second week of December?
without fail. Data positively on the
9 or 11 December. Any date.
without fail, as this is a long pending matter. No further adjournments will be allowed.
12. Obliged.
Lordship, in item number 2,
Hmm.
to the candidate be changed to Thursday, 20.
Can be. To 2020.
Obliged.
May it please, your lordship.
Please.
In this matter, the respondent filed an objection, whether it is tagged in the record or not, lordship.
Objection
Yesterday we have filed.
in I.
The lordship may take it at 2 p.m. lordship. In the meantime, this objection petition may be called from filing section, lordship.
Will they bring objection at
Or maybe it can take it up tomorrow if possible.
tomorrow? I don't know because tomorrow
Your
many
lordship
matters
is
have been
sitting
fixed
in
with the
division
DB.
bench, so if possible.
Tomorrow at 2. Up to your lordship.
I don't know. Let's see, we'll call for it. If it won't come, then we will fix it tomorrow at 2.
Lordship,
Not at 2, but tomorrow after DB.
lordship.
My lord.
Slip up on go.
Accommodate.
They will provide the slip, lordship, otherwise it will not come. Your lordship is.
No,
called-
he'll send it. He'll
Lordship,
send it.
obli-
Three, four লৈ গ'ল নেকি? লৈ গ'ল। Date লৈ গৈছে। Three, four লৈ গ'ল।
Ma'am,
Hmm.
the timing.
Hmm?
Timing.
Okay. Okay. Time being, all right.
2 p.m. ma'am.
No, 2 p.m. maybe.
Because all
Because,
the mentioned lordship,
because-
not many cases are left.
Because
See,
my
2
senior
p.m.
is,
already, huh?
my senior is medical. So it's,
In medical now.
So he might not reach. You can take
No,
an
the-
adjournment.
there is part
If
of-
they get adjournment,
Date may be given or two.
that will have to go because it's 2019 case.
Yes, no.
At 2 p.m., you see, I may not take up any matter at 2 p.m. because if this will come, then I'll take it up. And if this won't come, if you will wait, then I'll take at 2 p.m.
But it is answered. He has gone to
He is
hospital.
coming. My senior is coming.
On his way back.
On the way.
You want to wait, you don't want to wait.
It is uncertain, lordship, because he has
Uncertain,
gone
yes.
to a hospital. So
But he's on his way
Coming
back
on the
according
way.
to him. So then maybe at 2. Maybe, I'm not sure. Okay.
Obliged.
Item number 1.
Not figures. Prepared the matter, but out in a hurry, I brought the wrong file to the court, my lord.
This is 2011 matter.
Any day, my lord, I don't have to. Even tomorrow, I can do it, my
No,
lord.
tomorrow, I don't know because I'm in a DB.
Then Tuesday or Thursday, next Tuesday or Thursday.
Tuesday?
My lord.
Tuesday. Learned Counsel, Mr. Didas.
Be sure.
B. Sharma has submitted that he has not.
My lordship may not record that file.
So
Lordship may simply
in one gun, I'll grant and
Personal difficulty
Personal
of my friend. I consent, my lord. My
he has submitted that he has paid for adjournment on personal difficulties. Learned Counsel, Mr. B. Rathi, no?
D Rati.
D. Rathi is present for the respondents. List this matter positively for hearing on Tuesday, Lydia, without fail, as this is a long pending matter.
much obliged.
My lord, if it can be fixed at 2, because it's 2011, we'll get it, 2011 appeal if it can be disposed of.
At 2 today,
At
on 18 November.
on the 18th, my
Will
lord,
be
or
there.
today I'm convenient with whatever
If
my,
bench won't be there, then I cannot fix the matter for some other bench.
my lord.
Let it be.
Next
Let-
week I won't be there.
Tuesday, my lord, Tuesday.
It will come as first item only, my
Fine.
lord, because since 2011 matter.
Much obliged.
First of the day,
Passover for the day. Learned Counsel, Mr.
M. Hussain.
M. Hussain has submitted that the matter may be passed over for the day as his learned senior counsel, Mr.
R.I. Mandal.
R.I. Mandal has R.I. Mandal is not well or is in the hospital
In the
or
hospital.
is in the hospital.
Date may be
Learned
given.
Counsel, Miss R. Chaudhary,
R.D. Mujumdar.
R.D. Mozumdar is present for the respondent insurer?
In his case, I am the insurance. In my appeal, I am one. There are two appeals, Lordship. In
both-
7, I am respondent 1, and in 8, I am the appellant.
You are the
So I
for
am
the
the
insurer,
respondent. Yes, Lord.
is present for the insurer.
Yes, Lordship, that will.
Now leave this matter on, when do you want?
Short date,
Short date
short date.
20 November, positively without fail, as this is a long pending matter. Yes?
Maybe, the Lordship. I am for the item number 6.
Six. I'm so sorry, I have already given a date. You were here, I didn't see.
I am waiting for the 10:30 here. How? Who?
Somebody has mentioned just now.
I have not seen the other side.
And it was submitted that, that learned counsel is not well. That is why I didn't insist on the other side also. It's not well. That learned counsel for the petitioner is not well.
Well, I am the respondent in this case. Without my consent,
No. Actually, I haven't taken a consent because they have submitted that learned counsel is not well. That is why the consent was not taken.
no, your lordship, no, your lordship, it is a very long pending matter.
I understand.
Our matter is not maintainable. Here, we have supporting case laws. There are so many supporting apex court and this court. There are so many. But however it may be, yes, may kindly be considered for
Short date এটা দিয়েছো?
so.
December lesson needed to.
No,
27/11?
27/11.
Hmm?
Must have, right? It's a long pending matter. You know.
I'm really sorry, actually, I didn't see you and then I never thought you'd be present and then they have submitted the senior is not well.
They are taking this way.
Hmm.
Then this and that way they are taking the adjournment.
I'm
Must
really
be.
sorry to know that you are sitting for since 10:30.
So,
Oh, silent again.
Suit lordship, suit was decreed partly and thereafter lordship, suit proceeded ex parte against defendant number 528 lordship. Later on, we filed another suit and that was subsequently withdrawn lordship. And first suit was challenged by filing a title appeal along with a condonation application. Our condonation was rejected, so we filed a regular second appeal lordship. During preparation of the regular second appeal, the defendant number 528 were not made parties lordship. So an interlocutory application was filed, notice was issued and my learned friend appeared for them. As a civil number 1504 lordship. The objection raised by my learned friend is that the appeal, though it was admitted earlier lordship, in respect to this implicated person's appeal was not admitted, so the question of limitation will arise.
Okay.
But lordship, there is settled position of law that any party can be impleaded at any stage of the suit lordship if they are interested. And they are the main defendants who are made parties during the pendency of the suit. So it was
Dependent number how much?
528 lordship.
528. So this was dismissed against them, earlier suit.
Lordship may kindly see the judgment passed by the trial court.
528, 5678
Yes.
are the applicants now.
Respondents in the
yes.
IA.
They are the
In
res-
the,
they
IA,
are the
respondents.
oh, in the IA.
I want to implead them, lordship.
Okay. Are the respondents in the IA?
Yes, lordship. My suit was partly decreed. Page 27 order part says the suit is partly decreed on contest with cost. It is decreed and declared that sale deed number so and so is
Where
void.
is the judgment?
Appeal memo. I am reading from the appeal memo. lordship.
The recovery portion was omitted.
Hmm?
They did not get the recovery part. So they again, instead of filing appeal, they preferred a second suit. And then they realized that no, they should have filed an appeal against the earlier suit. So that entire duration of the second suit, they wanted to condone in the first appeal.
That was
That was
rejected.
around more than 3,000 something days. So that was rejected. Against that, they have filed a second appeal. In the second appeal, they have made all the main defendants party, but they skip the 528 main defendants. They did not file an appeal against us, the 528.
Lordship, may kindly see page 27.
You are defendant number 528.
Yes.
But Lordship, in the trial court, they did not contested the suit, Lordship. Page 27, your Lordship will find the suit is partly decreed on contest with cost. Page 27. Of the RSA appeal memo, Lordship.
Yes, yes.
The suit is partly decreed on contest with cost. It is decreed and declared that sale deed number 1933 dated 27/9/2005 is void. It is decreed and declared that the defendant number 528 did not acquire any right and title over the suit land by virtue of purchase. They did not prefer any appeal and we also did not prefer any appeal, Lordship. That recovery part was not given. We ought to have filed a first appeal, Lordship. It was partly decreed. And then later on, at the advice of some advocate, Lordship, second suit was filed for recovery of possession, Lordship.
Who is under possession now?
They are in under
All
possession.
the defendants.
Yes,
No.
Lordship, this 528.
This 4 defendants.
528 are
Their
under
purchase
possession.
deed was held to be void.
Hmm.
They do not have any right title interest. It was already held, but they are in
But they are in possession.
Yes.
possession. Then we filed a second suit
Hmm.
for recovery. And when it is realized that earlier suit can be challenged by way of first appeal, so that the relief was already sought in the first
So
suit,
there was a delay of 3,000 days.
something that was rejected against this regular second appeal. Second appeal was already admitted. And service complete LCR received at the time of hearing of the appeal, a question arose why the main defendants are not contesting, even if after service of notice, Lordship. Then I noticed that the 528 defendants were not made parties, Lordship. Then this impleadment application was filed.
Yes, your objection?
Well, my understanding is very simple, madam. If a party is impugned by any particular judgment, then they will prefer a second appeal. And the period to file a second appeal is 90 days. So that is the mode prescribed under the CPC. Any party who is aggrieved by any judgment in the title appeal, they will prefer a second appeal within 90 days. So if they do not file a second appeal within that prescribed period, then with respect to those parties, the judgment is confirmed. Confirmed. That part is gone. After 90 days, if they again want to implead or want to file a second appeal, then they will have to, that the mode is already prescribed. They will have to file a delay condonation, like in any normal case. If I do not file a second appeal within 90 days, first I'll have to file a delay condonation. If the delay is condoned, then my appeal will be heard for admission. So similarly, they did not prefer an appeal against us. 90 days is gone. So that means that judgment is confirmed against us. So now if they want, they can do that. The provisions are already there. They will file an application for condonation delay. If the delay is condoned, then the court will hear as to whether there are substantial questions of law against with respect to us or not. That is
I
the
think so, you cannot, I think so, he's right.
that is the manner already prescribed.
Lordship, I am
Order
relying
110
on a judgment.
Order 110, my lord, is for any person, that is stranger, any party, there is no
Yes.
bar. Any party can be included, but if there are main parties, then already the mode is there on the CPC.
He's right.
Yes,
No,
that,
Lordship, the case is that
They
Lordship,
are
that if
strangers.
they are not strangers, they are party already. Lordship may
Mhm.
kindly see this decision of.
They are necessary parties, but you
Yes.
cannot implead them.
Well, by mistake, they remain, Lordship. Otherwise, they are parties, Lordship. They have contested the second suit also, Lordship. Kindly see, Lordship, this is a limitation, on the point of limitation also, this judgment, paragraph 3,
Really?
Lordship.
Okay, then you can file a limitation is okay. Your delay has
Out
been
of the
controlled.
same judgment, I cannot
Your
file.
appeal has been admitted.
Yes, Lordship.
So it
As soon
appears
as
that
they
your
will
delay
be
has
ma-
been condoned.
Lordship, as soon as they will be made parties, then they will be regarded as a main respondent in the appeal also, Lordship. Lordship, kindly see this judgment, paragraph 3, Lordship.
Yes. Please read.
In section 21 of the Limitation Act, we find that where a new party is substituted or added either as plaintiff or defendant, if the court is satisfied that the omission to include the new plaintiff or defendant was due to mistake in good faith, the court may direct that the suit as regards such plaintiff or defendant shall be deemed to have been instituted on any earlier date. However, it is not the case of adding new parties. It is seen that when a new party is added or substituted and the omission to add or substitute, if found to be a mistake done by the party, the court has power to direct as regards the added plaintiff or defendants that the suit was instituted by or against them on any earlier date. As such, genuine omission or mistake in adding parties is not only excused but the court may direct that they were parties to the proceedings from the date of the institution of the suit. So in this case, Lordship, date of the admission of the filing of the regular second appeal. Suit is the
No,
No,
no.
no, this is for
appeal is
suit.
the continuation of suit,
This is
Lordship.
for suit,
This
my
is
lord.
for suit.
And
Appeal is
normally,
the
my lord,
continuation of suit, Lordship.
what
There
I-
are several judgments.
No, no.
Lordship.
What I understand, my lord,
I understand.
yes,
actually, the
if any
constitution of-
person normally,
Continuation of suit, but you
Yes.
have not included them in
yes,
earlier case.
That was only
Then
by
they had
mistake.
to be, this appeal had to be, second appeal ought to
Yes.
have been admitted for them also.
Lordship, during
Then their
admission, the
confession of
respondent has
delay will
nothing to
arise.
say, Lordship.
Huh?
During admission, the respondent has nothing to say, Lordship.
but,
No,
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 no, no.
but there, it has already been admitted.
Yes,
Yes,
Now
Lordship.
their continuation delay will arise.
yes. Then, my lord, what,
I do not
my
agree with
lord,
you.
what
Not
is
at
the
all.
use for
Then,
the
Lordship, I will satisfy your Lordship. That suit is the continuation of appeal, and in this judgment, the court
So this
already.
continuation of appeal, but not here,
Lordship.
not in this case.
Lordship.
When the RSA has been admitted against you, you must come by way of delay or a continuation of delay. This is what I believe.
Yes,
Lordship, that is a mistake on the part of the advocate, Lordship, not on the part of the client's Lordship. It was already mentioned in paragraph 5 also, that further should we punish the litigants for the mistake committed by the lawyer.
use
Let me
that
complete
90
this,
days
you
period.
take
Yes.
your seat, Lordship.
lordship is
Lordship, let me
putting up
complete, I
a,
am the
Please
appellant,
let her
Lordship.
complete this.
I do not
This
even
is
know
not
what
the
judgment is
manner of
splitting.
arguing a case.
I do
before
not even know
Honorable
what
High
judgment
Court.
is placing, why a copy has not been furnished to me.
I will submit my copy. Let me read the judgment first. This is not the way to argue a case before Honorable High Court. You should know
Please,
the
please, please
manner.
continue.
Lordship, paragraph 5. Further, should we punish the litigants for the mistake committed by the lawyer? This question came up before the Supreme Court under different situations. In Rafiq versus Munchilal, AIR 1981, SC 1400, their lordships observed, the problem that agitates us is whether it is proper that the party should suffer for the inaction, deliberate omission, or misdemeanor of his agent. The answer obviously is in the negative. We cannot be a party to an innocent party suffering injustice merely because his chosen advocate defaulted. In Goswami Krishna Muralilal Sharma versus Dhan Prakash so-and-so, their lordships expressed that if there was mistake committed by the lawyer, the party should not suffer. So, lordship, basically in this case also same problem arises.
No.
They were made as
No.
pro forma respondent.
No.
Then I will satisfy your lordship.
Hmm.
Appeal is the continuation of suit and the same principle
true.
apply to the appeal.
That I do believe. Why I also believe it is
Lordship.
a continuation of suit. But here you see, they cannot jump in without the proper formalities. They cannot jump in and contest the.
No, lordship, whether High Court is satisfied that there is substantial question of law or not, that only depends on the argument advanced by the appellants, lordship. For that, presence of respondents is not required
required.
unless until they filed an caveat, lordship.
Not at all.
So my appeal was already admitted. Thereafter, notice issued, lordship. So they have a right to contest the appeal on merit during the hearing, lordship. I will place.
They cannot brought in such a easy way.
But lordship, they are
Delay
the
has to be
parties.
condoned, I think. Maybe I'm wrong.
Lordship.
I have not gone into
Then
the
I will
depth.
satisfy your lordship that during admission of the second appeal, the presence of respondents counsel is not necessary.
No, that is not required. Not
Lordship.
required until and unless there is a caveat.
Yes, lordship.
It is not required.
Yes.
That I agree with you. Only this bringing the parties
Lordship, my appeal already admitted, they have nothing to
See,
say
when
against
there
that.
is a delay, the parties, the respondents, do not to be heard.
Lordship,
There is always a, you see, even in the second appeal, when there is a delay, we do not hear the respondents.
there is no delay, the appeal already admitted, filed in due course, Lordship. Within time it was filed, Lordship, there
No,
was no
but you
delay.
have said, no, there are a
No,
long.
that
delay.
is before the first appellate court, Lordship. Before the first appellate court, my condemnation was rejected, so the second appeal, Lordship, as per Shyam Sundar, Lordship. Rejection of
So, but you
condemnation,
were not there, present in the first appeal.
first appeal they contested, Lordship.
They were there in the first.
Yes,
appeal.
Lordship. In their presence, condemnation was rejected.
They were there in the first.
Yes,
appeal.
Lordship.
Okay, then we can implement them.
My understanding is very simple. If,
So they were there in the first appeal, you see.
yes, we are
Ah.
also in the first appeal. Now for some respondents, how can it be so that for certain respondents, the
Delay
limitation
was
to,
condoned in the first appeal.
no,
So against the first, the delay was not condoned.
yes, against that they have preferred the second appeal.
Against that they have.
So against some defendants, the time limit is 90 days. Against for some defendants of the same suit,
Yes, yes.
there is no limitation. That cannot be so much.
No. I'll give you a date.
I'll satisfy your Lordship.
That is what I understood
Yes,
initially.
yes.
Now. I
There
got the
cannot be
point.
two different time limit for
Yes, yes. no.
main parties in a same.
I'll fix a date then.
Lordship, after 2 weeks, any date. I will-
After 2 weeks,
I'll-
date may not be fixed.
As agreed by learned counsel for both the sides, leave this matter after 2 weeks.
Highly opposed.